Mr. Miller.
Good morning. I am the Clerk Registrar for this hearing. Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of BE on behalf of JE and Provincial Minister, Western Cape Social Development for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please the court, I appear on behalf of the applicant, together with my learned friend, Mr. Rademeyer.
Thank you, Mr. Schulte-Douglas.
If it pleases the court, Chief Justice and Justices, I appear for the respondent, together with my learned friend, Mr. Papier.
Thank you, Mr. Jeremy. Mr. Schulte-Douglas.
As the court pleases. Chief Justice, I intend to deal with the question of jurisdiction, the interpretation of Regulation 30 in brackets 4, the question as to whether delictual liability ought to be imposed for failing to ensure that a quality assurance assessment was undertaken. That bleeds into the question of wrongfulness. And then the residual issues of negligence, factual causation, which is raised for the first time in this court, and legal causation. In relation to jurisdiction, in paragraph 12 of our learned friends' heads of argument, they make the statement that the applicant's case also does not require the consideration and application of some constitutional rule or principle in order to decide the matter, and indeed none is identified in either the application or the applicant's heads of argument. We submit, on the contrary, that in the founding affidavit at page 161, which is in volume 3 of the record, we commence, or the deponent commences to deal with the constitutional issue that is raised in this application, and if it is granted this appeal, by saying that the matter involves the constitutional rights of children in terms of section 28 of the Constitution. And similar allegations are made in paragraph 10 and in paragraph 40 of the founding affidavit. They are repeated in our heads of argument on page 5 at paragraph 13. So we say with respect that it is an issue that's raised on the basis of jurisdiction lying as a result of a constitutional issue. And we say that the interpretation of Regulation 34 implicates fundamental rights of children and is inherently linked to the constitutional objective of section 28 of the Constitution. In Paulson, some surprise was expressed by this court as to why the appellant had not relied on a constitutional court, a constitutional matter to seek jurisdiction in this court. In paragraph 14, the court said, at first glance, it would seem obvious to base this court's jurisdiction on the claim that this matter raises a constitutional issue. That is so because this court has previously found that the interpretation of the National Credit Act implicates constitutional issues. And references there made in the footnote to a number of cases in which that was the case, including Sabola, which is a case referred to by our learned friends in their heads of argument, and where, because constitutional issues were implicated in the interpretation of the National Credit Act, it was found that it engaged this court's jurisdiction. And we say by parity of reasoning, that must be the case here. And in the interpretation of Regulation 34 must take place through the prism of sections 28 and 39(2) of the Constitution. We are criticized for not having made that case out. We think we have made that case out. But even if that criticism is valid, it doesn't matter. It's not a case for the applicant to make out. It is the law. All things must be seen through the Constitution. There is no other way of properly interpreting Regulation 34, given that it relates directly to the interests of children, an issue that is recognized by our learned friends in their heads of argument at paragraph 48 on page 16, where they say Regulation 34 cannot be interpreted in isolation, but must be interpreted in its constitutional and statutory context and with due regard to constitutional norms and values. That is precisely what we say. We say for that reason it engages this court's jurisdiction as a constitutional matter. We say also that it is a matter that raises an arguable point of law of general public importance, which ought to be considered by this court, and that, of course, is dealt with comprehensively in Paulson under the headings at paragraphs 20, 25, and 29 of the judgment. And if we can touch briefly on those, the point is manifestly one of law. It is the interpretation of a regulation in the context of determining whether delictual liability attaches to the respondent arising from a breach of its public law duty imposed by Regulation 34. Interpretation is a matter of law. The imposition of delictual liability is a matter of law. The fact that we will in due course argue that the facts also come into that equation does not detract from the fact that it is unquestionably a matter of law that is before this court today. It is an arguable point of law, we submit, arguable in the sense described in Paulson. Barley held, Barley, of course, the case relied on as binding the SCA in this matter and binding the court of first instance in this matter. Barley held at paragraph 44 of the judgment that nothing in the legislative framework on which the Barleys rely is indicative of any intention to visit with delictual liability non-compliance with any particular regulatory function. So that was a finding on, we submit the facts of that case and the argument presented and the law considered. The SCA in this matter appears to have accepted in paragraph 45 of its judgment that whether or not the respondent owed a legal duty to a child was an issue that had to be determined having regard to the facts of the case. And we will show in due course that is entirely consistent with the approach this court has adopted and the SCA has adopted to this question. But in the same paragraph, in paragraph 45, the court held that the High Court in this matter was bound by the doctrine of stare decisis to follow Barley in finding that the respondent owed no duty to in effect, any children in a place of care, including an early childhood development center in the province. We submit that this is at odds with the correct approach articulated by the SCA in cases like Olitsky, Knop, and then more importantly, by this court in Mashongwa. Ultimately, as those cases show, the approach to the imposition of delictual liability is flexible, taking into account, as it must, the considerations set out in paragraphs 25 to 27 of Mashongwa and paragraph 12 of Olitsky. In paragraph 26 of Mashongwa, the Chief Justice said that safeguarding the physical well-being of passengers must be a central obligation of PRASA. It reflects the ordinary duty resting on public carriers and is reinforced by the specific constitutional obligation to protect passengers' bodily integrity that rests on PRASA as an organ of state. Now, we can formulate that to apply to the facts of this case, but it should be obvious with respect the implication of that particular dictum, which forms part of the broader discussion in that portion of the judgment.
Mr. Schulte-Douglas, the 10 minutes has expired.
Yes, certainly.
Thank you.
If I may proceed until interrupted. The most notable aspect of the application of the doctrine or the approach in Mashongwa is that public policy considerations based on the norms and values of our Constitution are required to be taken into account. We submit that it's not therefore correct to say, as the SCA did, that because the court in Bali held that nothing in the legislative framework on which they relied indicates that delictual liability should be visited on the respondent, that is a conclusion at which a court is bound to arrive in any case where a child is injured in an early childhood development center. In other words, to put it simply, it was wrong to say that the decision in Bali was one to which the doctrine of stare decisis operated so that no other court could find differently on different considerations in the future. The approach by the Supreme Court of Appeal in holding that the High Court was bound to come to the same conclusion is, at least we submit from a jurisdictional perspective, arguably wrong. It appears to have led to the Supreme Court of Appeal taking the view that it could rely on evidence adduced in Bali as having been adduced in this matter. And that's clear from page 211 of the record in volume 3, paragraph 37 of the judgment of the SCA, where at the top of page 211, the court holds in Bali, the evidence showed that there were around 1,400 unregistered early childhood education facilities and so forth. That's not permissible with respect. to take evidence in another case, evidence that had been rejected by the court of first instance in that matter, and simply apply it to the facts of this case, unless there are some compelling circumstances such as that those facts are binding on the parties in this case, which we submit.
Mr. Sholto Douglas, can you please help me with the interpretation of Regulation 34? Please give me your understanding thereof, because I think it's going to be crucial to the determination of this matter.
Certainly, Justice McClunkey. Of course, Regulation 34 wasn't considered in Bali, and we've emphasized the importance of that particular aspect. If one looks at Regulation 34 as the SCA did in the context of the whole of Regulation 30, one sees that Regulation 30 applies to the registration of children's homes, what must accompany an application for registration, and the kind of details that one needs to place before the provincial minister or the director general in order to consider an application. Then Regulation 4 comes in, sub-regulation 4 comes in that context. And it says, registration of a children's home, place of care or shelter shall be reviewed every 24 months. Fair enough. That's a self-standing provision on the basis of a quality assurance assessment undertaken by appropriately trained officials appointed by the Director General. Now, we can see that Regulation 34 imposes an obligation to review the registration of a place of care every 24 months, but it doesn't stop there. It states that that review must be carried out on the basis of a quality assurance assessment undertaken by appropriately trained officials. Those words we submit, and we submit this as important, those words would be entirely superfluous if all that was required was, as found by the SCA, that appropriately qualified persons assess whether the people and organizations operating the place of care were suitable to manage and conduct it, so that in turn it would be suitable for the safe reception and care and custody of children. It would be entirely superfluous because that's already dealt with in the paperwork that is part of the registration process. And if all you're doing is reviewing the registration, you're just going over the paperwork again, or the renewed paperwork in order to consider it. But let's look at what the department does. Let's look at how the state entity charged with doing this behaved. And we can look at that on the basis of this court's judgment in, for example, Marshall. One can look at the way in which an organ of state has behaved consistently in the way of a custom over a period of time to see how they interpreted their obligations. And we see there the guidelines. And we see in the guidelines a quality assurance assessment. Now, quality assurance assessment is something of a term of art, and one sees it in industry and one sees it in all sorts of applications, but it means that somebody looks at how something is working to ensure that the quality of what is produced is adequate. It's not a paperwork or desktop consideration of issues. It is a going to look. A quality assurance assessment must be undertaken, and it must be undertaken by people who are properly qualified. And in volume 2 of the record, there is at page 142 as an appendix to the guidelines, the format of the quality assurance report or the assessment, and the report starts at page 143, and it's a standard quality assurance report layout. One's got to put all the details, and then on page 144, premises and equipment. And whatever else there may be said about the municipality and the obligations in relation to buildings and so forth, the obligation in relation to equipment and the premises rests on the respondent. And what has the respondent got to look at? It's got to look at outside areas, outside play equipment, fencing, the swimming pool, if there is one. How does one do that without a physical assessment of the facility that is subject to regulation by...
That inspection, Mr. Sholto Douglas, am I correct to say that it's done once every 2 years?
That is the...
To registration of the childcare center.
Correct, Justice Mhlankla, that is the minimum requirement. And the evidence was that visits took place more frequently, but yes, every 2 years it had to take place. So if I may move on to the question, so we say, just in summary, that the correct interpretation of Regulation 34, and I was dealing with it in terms of an arguable point, but it's our firm submission, requires a quality assurance assessment undertaken by appropriately trained officials, and that is the obligation. Somebody must go there and inspect those items, such as playground equipment, fences, and so forth, to determine that it's safe for children. That's the whole purpose, that there is oversight.
Mr. Sholto Douglas, I'm sorry to interrupt you. While we're dealing with the obligation in respect of outside equipment, what is the obligation on the child care center in respect of outside equipment?
Justice Tron, there is undoubtedly an obligation on the child care center, and it's coextensive with that of the minister. But the minister has a higher obligation because that's imposed under the Act read with the regulations. And perhaps I can just develop that very briefly. The SCA,
before you develop it, Mr. Sholto Douglas, why did the High Court not deal with the obligation on the child care center?
Because that wasn't an issue before it. As we submit in our heads of argument, there was relief sought against the child care center, and that relief was withdrawn in terms of a settlement. But so that wasn't an issue before the High Court. And one accepts, with respect, Justice Turon, that there is coextensive obligations on the child care center. And we're not saying that this is exclusive, but what we are saying is that there's an overriding responsibility that rests on the minister. And the SCA drew a distinction between the position under the South African Schools Act and under the Child Care Act to say, well, the public schools are owned by the government or by the province, and therefore there's obviously a different level of obligation. But with respect, that overlooks the fact that in effect, early childhood development centers are public schools that have been outsourced. They are not owned by the government. That is correct, but it is an outsourcing of what must be a constitutional obligation to care for and educate children and look after children.
Mr. Shelter Douglas, if there is, if we presume or accept that there's liability, or there ought to have been liability on both the childcare centre and the provincial minister, does the question of apportionment come into play?
Well, it would in the ordinary course be joint and several liability. Obviously, if money has been paid by the childcare centre, that couldn't possibly also be recovered from the respondent in this case. But apportionment was never pleaded, and apportionment was not raised as a defence or in relation to any third-party notice. So with respect on these pleadings and on these facts, the outcome, had the child care centre remained a party to the proceedings before the High Court, the order would have been one of joint and several liability in the absence of a prayer for apportionment, which there wasn't, or even an allegation that would support a prayer for apportionment.
Because I asked this also bearing in mind Mr. Hillman's evidence. His evidence was that a casual observer would have noticed that the swing was defective if somebody was playing on it by the sounds emanating from it. Now, wouldn't a teacher at the preschool who was supervising the children playing have qualified as a casual observer who would have noticed this?
I have no difficulty with the proposition, if this is what is behind your question, Justice Theron, that there was negligence on the part of the teachers or staff at the Early Childhood Development Centre, because they should have noticed it. Our learned friends say that you can't accept what Mr. Hillman says because it's contradicted by Ms. Weingaard, but it isn't. What they did was insufficient. They walked out before the children went into the playground to see that everything was all right. There was mention of snakes. There was mention of anything obviously dangerous. One imagines broken bottles or something that could harm the children, a hole in the fence, something like that. What there is absolutely no evidence of is evidence that the teachers or the staff observed the playground equipment from a safety point of view while it was in use. And that's when this would have been obvious to anyone. From the mere fact that the metal strips that held the swing cross member in place failed, that, as Mr. Hillman said, that would have taken a considerable period of time for that metal fatigue to work and to loosen everything up. The defective nature of the swing would have been obvious to anyone who took the trouble to look. And that's why he says, well, in order to see the defective design of this swing, you need a matric and some training after that. But to see it in operation as being defective, you needed to be a passerby who took the trouble to look. So, and we've dealt with that in our heads of argument of paragraph 61 to 62, very, very briefly. But we say there's no question that had, firstly, to answer your question, Justice Theron, of course the staff members should have seen. With respect, it's unlikely that they didn't, but they said they didn't notice. That in the context would be negligent because they should have noticed. But that doesn't also mean that in biannual inspections of the property by somebody appointed by the respondent and appropriately trained, and that's a really limited level of training we're talking about, a social worker who's taught a bit about playground equipment, that person wouldn't have picked this up. Firstly, that there was a design problem, and secondly, that it was in the process of over a period of time failing. This was a swing used in playtime by children. Well, I don't know, 15 minutes, half an hour a day. It's not a swing that's in constant use that would fail in a short period of time. It takes a long time.
Dr. Douglas, may I just take that point further, raised by my sister Theron? If you look at the evidence at volume 2, page 97, that's the evidence of Ms. Weingart. You'll recall that she was the educator, the teacher who came upon the scene where the child was, after the child was injured. And I'd like to take you to the bottom of that page 97 from around line 24. You'll recall in evidence in chief, she'd said that after she testified about having gone to the scene where the child was injured, she said that the equipment was what she called in a reasonable condition, a redelike toestand. Then she's asked under cross-examination by Mr. Peppier, what did you specifically observe? He says you watched the children, it was die kinders dopgehou. Did you see any loose metal parts? Het jy enige los metaalstukke gesien? And she answers at the top of page 98, line 2, and I'm translating loosely, no, I haven't seen any loose parts, and if I'd seen something wrong, usually if we see something wrong, we'd place a red and white tape around it. Ek het nie glad nie los goed daar gesien nie, en wat ons, as ons iets foutief is, dat is gewoonlik 'n rooi en wit band wat ons om plastiek wat ons ombind om te wys dit kan nou nie gebruik word nie. So she's giving direct evidence that as far as she's concerned, she hadn't seen anything wrong. Any comment on that?
Yes, thank you, Justice Majid. That must be seen in the context of her evidence as to what she does or what the staff do. They go out before the children go to the playground and they check, is anything wrong? If the cross member had fallen in the night for some reason, she would have picked it up and put a red and white plastic tape around it on her evidence. But what there is no evidence of is of the staff members checking the functionality or functioning of the playground equipment while it's in use. And it's explained perhaps on page 110 of her evidence when she's being cross-examined by counsel on behalf of the municipality. And she says at line 3, we would just have to go and make sure, is there anything there, something perhaps that's broken, that a person would have to climb over, or children would perhaps have to play on that thing or around that thing. They could have interfered with something, gepeter. Therefore, we were asked, to go out and to look of whether everything was still all right, there wasn't something that was broken, and for any oddities, any strange things, ongediertjies, lying on the ground. And she speaks elsewhere of snakes, that sort of thing. So they go, one envisages the children inside the building, a staff member going out into the playground immediately before playtime, having a quick look around. Is there anything here that's going to harm the children? A person, she would have seen the swing would have had its cross member on the top. It wouldn't have made the slightest bit of difference. What is not the evidence is she goes walking around, looking at the roundabout, looking at the seesaw, looking at the swing, looking at the jungle gym, while the children are playing on it, to see whether it's all working well and safely. That evidence isn't there. And that appears not to have been the case.
Yeah, I understood, just in conclusion, I understood that question by Mr. Papier, the one I read to you at the bottom of page 97, to relate specifically to the time of the incident when she went to see the child there. But you don't read it like that. You read it as a general observation.
Yes, because I see just at line 10 on 97, or perhaps line 8, who went out on that day to go and look at, before the children went out, at line 8. And she says, I don't know who went out. She says that, and then she deals more generally with what happens. So that's my reading of it. Yes, indeed.
Yes, thank you.
Mr. Shelter Douglas.
Yes, Justice Scheffler.
I just seek clarification from you on the point of law. As I understand it, and correct me if I'm wrong, the law is that a public law duty converts into a private law duty for liability in delict, where it is clear that the legislature intended the breach of the legislation to be visited with delictual claims or delictual liability. Am I wrong in articulating the principle in that way?
Perhaps I can answer that, Justice Jafta, by saying that as I understand the cases, in Mashongwa in particular, the imposition, the starting point is a public law duty doesn't mean a delictual law duty.
Yes.
Imposition of delictual liability occurs when considering aspects of public policy informed by the Constitution, the moral indignation of society, the expectations of society, considering constitutional norms, it is correct to impose delictual liability. In other words, it's not merely an interpretive exercise. Can I interpret the piece of legislation to impose delictual liability? That was, if I may put it, the pre-Olitsky approach, and certainly the pre-Mashungwa approach. So in my submission, the question is this flexible public policy-based decision, and it's said with great respect very clearly in Mashongwa at it's actually in our heads of argument. Bear with me a moment, I apologize.
Okay.
We actually we deal with it under legal causation. It's on page 30, paragraph 63 of our heads. Where in relation to that case, the learned Chief Justice said, the incident happened inside Price's moving trains, etc. Price's failure to keep the doors closed is the kind of conduct that ought to attract liability. This is not only because of the constitutional rights at stake, but also because Pricer has imposed the duty to secure commuters on itself through its operating procedures. It is inexcusable that its passenger had to lose his leg owing to his failure to do the ordinary. This dereliction of duty certainly arouses moral indignation. And that is an application of the test that is set out earlier on in the judgment at paragraph 25 to 27, which is to acknowledge that it's a flexible test based on public policy considerations informed by constitutional norms. So one can have a piece of legislation that says nothing about delictual liability, that gives one no clue one way or the other as to what the intention of the drafter of the document may have been. But one may say on the facts, it's wrong not to impose.
I understand that. I thought they are separate propositions. The one that you have just articulated, which is based on the facts, and asking a question at the end of it, whether or not it would be contrary to public policy to impose liability in the context of the facts. I think that is a normal common law approach. That's why the development has become incremental. That I understand. I thought, and I may be wrong, I thought the proposition arising from Oliski, which was confirmed by this court in Steenkamp, was you may have a starting point where there is a public law duty, but that duty also leads into a private law duty in delict under certain circumstances. I am not quite clear as to the test. What are you looking for in order to move away from the public law plane and get into the private law plane? That's what I was looking for. I'm not quite clear.
So, Justice Jafta, my understanding of the cases to which you refer and the others along the same line are that one establishes by considering the legislation, for example, the existence of a public law duty. Then one looks at the facts of the case and one applies the flexible approach that's referred to in Olinsky. And one says, in determining whether delictual liability should be found on these facts, we've got to look at public policy issues informed by the Constitution. And we've got to look at whether it would invoke moral indignation not to compensate Janica for her loss in this case. We've got to look at, for example, the floodgates argument that has been put up. And there's no, in this case, potential floodgate because we don't know of hundreds of children who have been injured in early childhood development centers. There's simply no basis for that. It's a red herring. But those are the kind of issues one looks at. And one says, in all the circumstances, should we impose delictual liability on top of the public law liability? And the older cases would say, well, you've got to look at whether or not there's a criminal sanction, whether you've got to look at whether or not there's specific reference to delictual liability, perhaps a limitation of liability in the Act or something like that. That's not the approach, as I understand it, in the constitutional era. It's a more flexible one.
Correct me if I'm wrong. My understanding may be wrong again. I understood Olinsky and Steenkamp to be saying, where in the context of public law, there's a remedy for breach. Ordinarily, you can't infer that the legislature intended delictual liability to attach. Am I wrong?
No, that's
misunderstood.
No, with great respect, that is correct, and that's one of the issues that comes into play. So, I mean, one doesn't ignore the document you're looking at. I accept that. And that's an issue that comes into play. And there's none here.
Okay, thank you.
Thank you. I think I've got 1 or 2 minutes just to end up. We've dealt with the question of negligence.
Douglas, just to take you back to Regulation 30, subsection 4, which requires quality assurance assessment undertaken by appropriately trained officials appointed by the Director General. Do you submit that for the minister to fulfill her legal duty, officials would need to be able to properly examine the entire premises of the ECD centers, including outside play areas?
Yes, Justice Kampepe, and that is what I understand that they do. And that is what the guidelines require of them. And that is what the quality assessment form requires them to do. They would have to look at everything. They don't have to inspect buildings and whether the buildings are working or that's the municipality's job. There's a clear division. But in terms of the safety of the children, yes, they must look at everything, including playground equipment.
How do you deal with the minister's submission that such a requirement would impose undue financial and resource burdens on the minister?
There is simply no basis in the evidence for that submission. There's none at all. One is left to speculate. If one does speculate, it's simply a matter of training the social workers who go there anyway to keep an eye out for certain basic potential defects in playground equipment, or at the very least to say, just check if it's working, sit on the swing, see if it's sturdy. That's all it takes in a case like this. Look at the fence. Is there a hole near a busy road? You must do that as the minister's social worker in a case like this. It could hardly be suggested that if there was a hole in a fence near a busy road, and in fact, as we know, social workers go to these early childhood development centers and they carry out inspections, that wouldn't have fallen within the purview of the social worker. And now we've got something that was not as obvious as a hole in the fence. So now we've got to train those social workers to say, look, just wiggle the swing, see if the seesaw is solid, the roundabout doesn't come off its axis, that sort of thing. It's not a university degree, it's an afternoon's training. So it comes, unfortunately, the argument comes from the SCA taking the evidence out of Bali and putting it in this case of 1,400 ECD centers in the province and 16,000 social workers, and they're not enough people. But with respect on the evidence in this case, there's no basis for that submission.
Mr. Shelter Douglas, just to follow on from the question of my sister Kampepe relating to the duty on the minister. In paragraph 56 of the High Court's judgment, there's a reference to an agreement between the municipality and the MEC, in terms of which the MEC agreed to take on the responsibility of inspecting outside play equipment.
Yes, so Justice Turon, that was the fight between the minister and the municipality. They had a side fight. In fact, the whole case was pleaded and run by the minister on a completely different basis to that is advanced now. And it was in essence that it was the municipality who had the duty to inspect the playground equipment, not the minister. And that issue was decided against the minister, and the minister has never appealed that decision. So that is raised judicata in terms of the municipality and the minister. There is no such agreement. There is no obligation on the municipality to check the playground equipment. The obligation is on the minister. The minister's contentions to the contrary failed in the High Court, failed in the SEA, and are not subject to appeal to this court.
Yes, this brings me to my question, Mr. Shelter Douglas. If you are at paragraph 56 of the High Court judgment, was there an agreement as was referred to in that paragraph? Was there an agreement between the municipality and the minister in terms of which the minister agreed to take on the responsibility? If there was an agreement, is it relevant in this matter? Is it relevant in the case before us?
There was an agreement. There was an agreement. Is it relevant? Bear with me, my lady. Yes, it is relevant. It's part of the way in which the minister perceived her duties to be. Yes, so I would submit so.
Now, the High Court took that a step further. In the same paragraph 56, it said, the minister would not have taken on that responsibility if there were capacity or financial issues. Now, this leads me to paragraph 44 of the SCA judgment.
Yes.
Where the SCA talks about imposing liability in an indeterminate amount for an indeterminate time to an indeterminate class. And in the sentence before that, it says, accordingly, the duties alleged would, if imposed, apply in all 9 provinces in literally thousands of places of care. Does this apply, or does this reasoning apply where the minister responsible themselves have accepted this duty?
No, it wouldn't apply in those circumstances, Justice Turan. And with respect, as I've said before, there was no evidence. One can accept that it would apply across the provinces, but as to literally thousands, there was no evidence. So yes, on both counts.
What would the applicant's argument be in respect of paragraph 44 of the SCA judgment, having regard to what is in paragraph 56 about the responsibility that the minister has accepted?
Well, the fact that the minister accepts liability is a reason why this consideration or this third policy issue is with respect a red herring, something that ought not to have been taken into account. It's one of the reasons. The fact that the minister assumed responsibility is one of those reasons.
Yes, thank you, sir.
Thank you, Justice Trump.
Douglas,
yes.
Can I just ask you? Am I correct in thinking that the evidence suggested that there was a certain Miss Bali, the ALIE, from the department who inspected the equipment in April 2008?
The evidence was that Ms. Bali, who was the social worker, came to the premises in 2008. But there was no evidence that she inspected the playground equipment. And it's difficult now without that evidence, but the evidence that she if I recall correctly, that she walked out into the playground. But there was no evidence of an inspection of the playground equipment by any member of the minister's staff.
But we do know that Ms. Bali came at the instance of the department, and she did go towards the playground area.
Yes, and her
Let's
evidence.
talk about what we know. She did go towards the playground.
Yes.
And we do know that what we do know is that she did not give a report that there was anything untoward concerning the equipment.
We do know that with respect, and we do also know that she went substantially more frequently than every 2 years. If my memory serves, it was something in the line of 6 months.
And we do know that this unfortunate accident happened 4 months thereafter.
Yes, quite right, Justice Tiki.
What concerns me about that is really, and perhaps it ties back to Ms. Waingart's evidence, because when I took into account Ms. Waingart's evidence, where she said that she observed nothing untoward when she made the observation. And then I think of the fact that Ms. Bali went there 4 months before the accident, and we know there's no report, and she had gone to the play area. How do we reach a point of then saying that, one, the department did not do what it was supposed to do? One. And then secondly, to then say that they were negligent.
So, Justice Tiki, I think the answer to that is twofold. Firstly, the fact that an untrained person, or a person not even alerted to what they're looking for, walks out into a playground when there are no children there and sees nothing amiss, just doesn't take the case any further. Postulate Ms. Bali or Ms. Weingart walking out into the playground, no children there, the swing not in use, the cross members sitting on top, there would be no reason to suspect that there's anything wrong. That is why the obligation is to use appropriately qualified persons. And the first part of the argument is design. A person who had been pointed to the sort of design flaws to look out for would have picked up the design flaw without anybody having to draw attention to it. The second leg of the argument is function. Mr. Hillman said that this deterioration would have happened over a long time. So 4 months before the incident in question, had Miss Bali put a child on the swing, herself sat on the swing, operated the swing to see whether it was safe or not, she would, on the probabilities, have seen that there was something wrong. The same can be said for Ms. Weingart, of course. But if anybody knew what they were looking for, or if anybody saw the way the swing worked in use, they would have seen a problem. And with respect, what happened to Janica was entirely foreseeable. The minute you understand that if the cross member of the swing is going to fall, it's going to fall on a child. It may very well fall on their head. It's a heavy piece of equipment, and it's going to cause the sort of brain damage that Janica now suffers from. So we say that's negligent not to have sent an appropriately trained person, which doesn't mean you have to send an engineer around to every early childhood development center. It just means, social worker, we want you to look for this, and you must just test the equipment, make sure it's all working correctly. That's all you need to do. And Janica would not be brain damaged today.
Mr. Sholto Douglas, forgive me if your argument has touched on this. What prescript stipulates the form that a quality assessment should take And does that prescript also stipulate that the grounds, the playgrounds should also be assessed?
So the prescript is the guidelines, and the guidelines do on page 142, which is an annexure to the guidelines. Now, I accept that the guidelines aren't law. It's not a statute or a regulation. But
why I used the prescript, I exactly wanted something that has the force of law.
Okay, no, it doesn't have the force of law, but what it does have the force of is evidence going to interpretation of Rule 30, of Regulation 34, because it is evidence of the customary way in which the minister dealt with the obligations imposed upon her under the regulation. So it's that kind of subsequent conduct that the law allows us to use as an aid to interpretation, particularly when there are potentially two or more interpretations. So that is, it's not a prescript in the sense that you suggest, Justice Madlanga, I agree, but it says this is what the minister gave to the minister's staff who were charged with complying with the obligation to do the quality assurance assessment. And this document says, check the outside play equipment, check the fence, check the swimming pool if there is one, and so forth. So it's not law, it's not statute law, but it's an aid to interpretation. We've dealt in responding to the questions from the court. I've dealt with factual causation, legal causation. We've dealt with in our heads of argument. Again, we rely on Mashongwa and the passages that we've cited in our heads of argument in that regard. We say that liability arises in this case. In paragraph 66 of our heads of argument, we set out the relief we seek, which is different from that sought in the application, but it's defective in the sense that it doesn't ask for the application for leave to appeal to be granted with costs, including the costs of due counsel, and it also doesn't ask for the appeal to be upheld with costs, including the cost of due counsel, and we just wish to make plain that we seek orders in those terms. Otherwise, those are our submissions.
Thank you very much, Mr. Shelter Douglas. Mr. Jamie?
As the court pleases, Chief Justice, Justices. In addressing the argument, I'm not going to stick to the script that I'd prepared because I do want to engage the issues that have come up in debate. And I also don't require, upon reflection, the 10 minutes injury time. I'm happy to engage with questions from the members of the court as and when they feel the necessity to raise them. Could I at the outset deal with two factual aspects which have arisen in the debate, the one through Justice Tron and the other one as part of my learned friend's main address. We dealt with the question of negligence and what the evidence of Mrs. Weinhardt, properly construed, dealt with and didn't deal with. And I need to correct with respect those two aspects because they do inform the debate as to the legal principles. And can I begin my address in regard to those two aspects by reminding the court, as the court to be aware, that this court in Barlow v. S made the point at para 9 that an appeal on the facts is normally not something that would attract this court's jurisdiction. This court does not deal with factual appeals ordinarily. Obviously, there are exceptions to that, but I state that as a legal principle to commence the factual debate. So the first issue I want to deal with was raised by Justice Tron toward the end of my learned friend's submissions, and it was about the agreement. And she referenced the para 56 of the Court of First Instance judgment, which the members of the court will find at page 251. And it refers to the alleged agreement. Now, unfortunately, you don't have the evidence of the parties in that regard before the courts. You also don't have the memorial of the so-called agreement. I don't want to go off the record and address the court on what that memorial, the form it took, because it's not before the court. So I'll confine myself to the fact that that memorial is not before the court. That's the first point. Secondly, the evidence in that regard is not before the court. What is before the court is the pleadings, and the pleadings do indicate that the minister never accepted, the MEC, never accepted the existence of such an agreement. So that is the first point with respect. Then, with regard to the SCA and the way it dealt with the matter, if the members of the court would go to para 48 of the SCA judgment at page 217, and before perhaps taking you there, can I just refer you to the order of the SCA, which you find at 219, and the order of the SCA in para 2 thereof, after upholding the appeal, the consequential orders were inter alia. Para 2, the defendant's claims against the third party are dismissed with each party to bear their own costs. Now that is the defendant being the present respondent, the third party being the Overberg municipality. So the respondent's claim against the Overberg municipality was dismissed with each party to bear their own costs. The reasoning and the ratio for that order you find at para 48 at page 217, where the court did not find as a matter of law or fact that the case had not been proven, but rather finds that the parties, both parties, were remiss in not invoking the provisions of section 41 of the Constitution and indeed 41 of the Intergovernmental Relations Framework Act in order to resolve the disputes between them and to arrive at what the court refers to as a suitable modus vivendi to deal with the issue of their respective rights and responsibilities after the primary issue of liability as claimed had been resolved. In other words, the claim by the plaintiff then and the present applicant. So the court was of the view this should have been dealt with not in legal proceedings between the parties, but rather in an intergovernmental manner. So you do not have before you, Justices, any finding that the claim against the municipality was unmeritorious. And that's the point we want to make from a factual point of view. Those are the facts. The second aspect, factually, that I wish to deal with is my learned friend's submissions that he made to you as to the import of Mrs. Vainfart's evidence. And in that regard, before dealing with that, he also, right toward the end of his submissions, submitted to you as a fact that Ms. Barley's evidence, or rather that the position with Ms. Barley's inspection, which was raised by one of the justices, I think possibly Justice Schluntler, was he submitted in response thereto that when Ms. Barley conducted, firstly, he was asked whether Ms. Barley conducted an inspection, and his answer was, well, she visited the facility, but there's no evidence that she conducted an inspection. Now, with respect, we take issue with that on two grounds. The first is that Ms. Barley's evidence is by agreement not before this court. But secondly, we have put up evidence aliunde in order to deal with the different points. And the court can, with respect, in terms of its rules, take cognizance of this. And you find this evidence aliunde in Appendix 4 to our written argument, being the chronology which was put up in the Supreme Court of Appeal by the respondent. And if you go to the second page of that document against the date of 15 April 2008, you will see with reference to the record before the SCA that Mrs. Barley conducted an inspection of the premises at Bubble and Crowell. So you can safely assume, Justices, that was never placed in issue in the Supreme Court of Appeal. So there was an inspection. Again, I'm not going to go off the record and tell you what the nature of that inspection was, but all I can submit in response to my learned friend's submission is that it's not open to him. And I don't for a moment believe that he attempted to introduce evidence through the back door. I know my learned friend well, he wouldn't do that. But I do submit to you as a matter of fact and law, you will not take into account his submissions to you that Ms. Barley's evidence was, or that the evidence in relation to Ms. Barley was that she either did not conduct an inspection, or if she did, that it wasn't while the play equipment was in use. That evidence is not before the court. The court would not properly be taking that evidence into account. So that's with regard to Ms. Barley. Then the more material submissions that he made relate to Ms. Weinhardt. You will recall from our heads of argument, we make the submission when we deal with Mr. Hillman's evidence, that Mr. Hillman's evidence was first at least vague, and I'm not going to take you to it. It's dealt with in our heads in some detail. That Mr. Hillman's evidence was at least vague with regard to, you'll find it on page 37 and onward of the of our written heads, para 84 and onward. And we have an extract from the evidence which makes it clear that he himself is not clear as to when the so-called movement would have been observable. So on the most elementary level, it wasn't his evidence, and he was never asked about this, that it would have been observable at the time Ms. Barley made an inspection, which was 4 months before the incident. That evidence was not before the court. But apropos what my learned friend submitted to the court as being the import of Ms. Weinhardt's evidence, and Justice Majid engaged with him on this, and his submission was that Ms. Weinhardt's evidence, if one looks at it, only related to an inspection carried out before the children used the playground equipment, and that there was no evidence that during the use thereof, they were observed, the children were observed. Now that evidence is simply, with respect, incorrect. Can I first deal with it on the basis of common sense and just the probabilities and the likelihood of what would have happened? And then secondly, to take you specifically to the record. On the level of common sense and what would ordinarily happen in the ordinary course of human conduct in a situation like this, where you have evidence that the teachers before every break, at least one of the three teachers or supervisors, whatever you wish to call them, goes out to inspect the premises, the outside premises, that they're safe, etc. And that if they are not safe, if something wrong is observed, they in fact tape it off with red and white plastic tape in order to make clear that it shouldn't be used. Can it ever in that context be suggested that those teachers and caretakers would not observe the equipment while in use by the children? Just as a matter of logic and common sense, that is highly unlikely, if not entirely improbable. It would be contrary to ordinary human experience for teachers to go to the trouble of taping things up and going out before each and every break. And that was never put in question, as we make the point, Mrs. Weinhardt was the plaintiff's witness, the present respondent's witness. So that was never put in issue. That they would do all of that, but then simply neglect their duties and leave the children on the playground unattended and unobserved. That doesn't make any sense. And if one bears in mind the evidence that this equipment was obtained from another school some 6 years before the incident and had been in constant use, the prospect of arguing that the teachers never observed the playground equipment in use and they were negligent, and thus they were negligent, apart from never having been pleaded in the case, and the allegations of negligence are pleaded in para 12 of the particulars claim, you will not find any such allegation, albeit those allegations are made against the respondent, not against the school. But that simply was not part of the pleaded case. But the second aspect, apart from the probabilities, is if one then has regard to the evidence. The evidence you find, Justices, at pages 93 and 94 of the record, which my learned friend did not take, Justice Majuto, when he was asked about this. So Mrs. Weinhardt was being examined by her own counsel, Mr. Rademacher, who was counsel for the plaintiff. This wasn't cross-examination at pages 93 and 94. And against number 14 on page 93, she says, well, the question first from Mr. Rademacher against number 11, line 11, kan nie vir die hof net kortliks in die eie woorde verduidelik wat daai dag gebeur het asseblief? Well, please tell us in your own words what happened on that day, the day of the incident. And she responds, ja, ons was in die eerste dit was eerste pause en ons was buite met die kinders. Ek, mevrou Jenus en Jansen, ons het onsself versprei tussen die kleuters, want ons moes nou toesig hou en. Roughly translated, which was the first break, we were outside with the children, myself, Miss Jenus and Jansen. We spread ourselves among the toddlers because we must now observe them. And then against line 22, so u sê jy het toesig gehou tydens eerste pause. So you say you observed or you kept watch during first break. The answer is ja, yes. En was julle buitekant gewees? Were you outside? Answer on top of page 94. Ons was buite, ja, op die speelterrein. Now, and then Mr. Rademacher asks against line 2, en die drie van julle was julle die hele tyd by mekaar, and she says, nee, of is julle uitgesprei, ons is nie by mekaar nie, ons is versprei tussen die kinders, tussen die kleerders, omdat ons mos nou moet toesig hou oor hulle. Goed, and then against line 10, en toe in my toesig hou, terwyl ek nou so omgestap het, en nou het ek vir Janneke Isa gesien op 'n swaai, en ek het seker net so wegbeweeg, nie lang daarna, weg van hulle af, nie, toe het 'n kind aan my getrek. And then what follows is an account of seeing Janneke lie on the ground. Now,
Mr. Jamie,
yes,
you know, not everybody is proficient in Afrikaans, so even some you may just give us a sense of what all that means.
I was literally about to do that, Justice. I'm sorry. I thought I'd just run through it instead of interpreting.
Okay, thank you.
And please bear in mind, Afrikaans is not my first language either, but I will try my best. What it says on page 94 is the three of you, were you always together? Were you together the entire time? And then she says no, and then he says, or were you spread out? And she says, we weren't together. We were spread out among the children, among the toddlers, because we had to keep watch over them. And then she says, and while keeping watch, while walking around, I saw Janneke Isa on a swing. And I must have then moved away, because not long afterward, moved away from them, a child pulled on me. Now that last evidence is quite crucial for the argument my learned friend tried to develop, because his argument, and remember I've already made the submission to you, Justices, it's highly improbable, if not entirely impossible, that over a period of 6 years, none of these otherwise apparently diligent caretakers, teachers would have observed the swings and the other equipment in use and observed the children on the equipment. But, and obviously, it's not a case, as my learned friend suggested, that they come out, inspect for snakes, etc., and then go inside and have a cigarette or a cup of tea or coffee, leaving the children outside. That's not the evidence, and it can't be made to read like that. That's not how anyone understood the evidence during the trial. And I emphasize this is the evidence of the plaintiff, the present applicant. But if there was any doubt about my submissions as to probabilities and likelihood and common sense and ordinary human experience, then this evidence lays it to rest, because not only is it clear that they remained outside on this day and no one asked them, was this day different to any other day? It follows inevitably, and we say unarguably, that this was also the modus operandi. In fact, that was the purpose of Mr. Rademacher's questions, to establish the normal modus operandi. And we submit, it's clear that this was what normally happened, this happened on that day. And most importantly, for the submission you heard from our learned friend, on that very day and shortly before the disaster struck, there's direct evidence, never controverted, from a plaintiff itself that Mrs. Weingardt looked at the child in question, the victim, on the swing and did not observe anything untoward. The only possible inference, and the fact that that wasn't elicited or elaborated upon further by anyone, is because it was so obviously the case. There was nothing untoward in what she saw when Janneke was using the equipment right before the incident. That is the inevitable conclusion to reach on any ordinary conspectus of evidence in a trial. And to suggest otherwise with respect is to twist, and twist is the wrong word, I apologize, is to strain the evidence to mean something and to convey something that it never intended to convey. Those are our submissions with respect. On the factual issues which go outside our basic submissions, then to turn to our submissions as such, we have dealt.
Excuse me, Mr. Jamie.
Sorry, carry on, my sister. Carry on, my sister.
Am I correct in saying that you did not take the 10-minute indulgence from the Chief Justice?
Perhaps unwisely, but I elected, given the short time I had, to not take the 10-minute indulgence.
In fact, Mr. Jamie, you did announce at the beginning that you're happy to be engaged from the very beginning.
Yes.
I did.
Yes.
Now, perhaps I should have asked this question from Mr. Sholto Douglas, but I didn't. But as you were arguing, making your submissions, I recalled that, in fact, Mr. Hillman, in page 65, in his evidence, said yes, the whole issue about the technical or the mechanical design needed a trained eye.
That's correct.
But that, because this accident was probably caused through wear and tear, that a lay person's eye would have observed if the machine was getting loose.
That's correct.
And he said that between line 15 and 20 in page 65.
Yes.
I'm asking this because you've referred us now to the evidence of Ms. Weingart, who said that they observed this before the children went to play, and that on that day they were around. And it just concerned me that none of the teachers, who I must say, perhaps they are like me, they are not trained, didn't even see it. And yet Mr. Hillman had said even a completely lay person would have observed that the equipment was loose.
Justice Shiki, we deal with this in our heads of argument at paras 86 to 90. And can I just take you to those paragraphs, perhaps? We do reference where in the record you found them, but perhaps for ease of reference, if you have my heads to hand, our written argument, unless the court would prefer me to take you to the record, can I take you to my written argument?
Well, personally, I went to the pages.
Okay. I'll take you to the pages, and you'd have to look at another document. It's page 62 of the record. Okay, yeah, at page 62 of the record, against line 19, Mr. Hillman says, I state the obvious, which I've already gone through, that the joining system was bound to fail eventually under the movement, and that I'm also of the opinion that the likelihood of failure should have been apparent to any reasonably competent person observing it in use soon after the facility was first made available for the children to play on. Now, we know that was 6 years ago from the evidence. So he's saying within a short, and we know it was also in use at another school before that. So you must now consider this evidence in the light of the fact that one school was using it, donates it to Bubble and Crubble 6 years ago. Bubble and Crubble erects it and continues using it for 6 years. Against that evidence, uncontroverted evidence, led by the plaintiff, he says, I'm of the opinion the likelihood of failure should have been apparent to any reasonably competent person observing it in use soon after the facility was first made available for children to play on. Because the moment you see movement in a situation like that, then it should start ringing alarm bells. And now these are the important words. And I don't know how long it took, because I don't know the actual usage of the facility before the thing was really flopping backwards and forwards, and the hinges were, obvious to any, even a casual observer, that there was something not right with the attachment. So we can just pause there. He's not talking now about the design flaw. He's talking about the movement, and his evidence in chief, this is cross-examination by Mr. Papier, is that he doesn't know when the thing would have been flopping backwards and forwards so that a casual observer would have seen that there was a problem. That's his evidence. And then he elaborates on that at page 65, where he says, that's the passage you just referred me to, Justice Shiki. He says, against line 14, I mean, to put it another way, for a person to look at a drawing of this construction when it was new, or in fact, even look at the facility when it was brand new, and to be able to say that's a poor design will take a higher level of training and understanding than it would for somebody going much later when the thing actually is moving and things have started to come loose, that should be obvious to even a completely lay person. Once again, it's his evidence that it should have been obvious and it would have been moving. Now, as we say in our written argument, the problem with that evidence is that it was not corroborated by the other evidence led on behalf of the plaintiff by Mrs. Weinhardt. And I've now taken you to the passages which make it clear that the teachers, including Mrs. Weinhardt, would have observed, and in fact, on the day in question, did observe the swing in use and did not observe anything untoward. That is the evidence before the court. And that is the evidence on which this matter was run. So in response to your question, Justice Shiki, our answer is you don't start by saying, well, Mr. Hillman's evidence must be correct, and hence there's a problem with the evidence, the other evidence. That's to put the cart before the horse. The proper approach to expert evidence always is, as we said up in para 90, that evidence is generally, opinion evidence is generally inadmissible. The exception, or rather expert evidence, is an exception to that rule. But in order to be of assistance to the court, it must be clearly based on the facts in the matter, or on facts that are postulated, which are then established in the matter. But if the opinion is based on facts that are either not common cause or not established, or are not clearly postulated and then found on the basis of other evidence in the matter to be the factual basis that the court accepts, that opinion evidence is worthless. So in this regard, for Mr. Hillman's evidence to be that the thing was flopping back and forth and therefore anyone should have seen it, when that evidence is not the evidence before the court, it's not firstly the evidence from Mrs. Weinhardt, and no one has ever suggested, including the applicant in any of the courts below, that Mrs. Weinhardt's evidence stands to be impugned in any manner. That has never been its case. It finds itself now having to argue that Mrs. Weinhardt can't be relied upon because it has this difficulty between the two sets of evidence. But that is the evidence. And so Mr. Hillman's expert opinion must be adjudged in that regard. And against that, against that factual matrix. And the second aspect with respect is that when, and we deal with this in para 91 of our written argument, when Mrs. Barley inspected the premises in April 2008, there's no indication, in fact, there's no indication at all that she did an inspection that was merely a look around or that didn't involve the outside equipment, but there's also no indication that she found anything untoward. So those are the facts. Yes, Justice Rob.
Sorry to interrupt you. On the question of Ms. Barley, who would bear the onus to establish that she carried out a proper inspection?
To the extent that the respondent relied upon the evidence of Ms. Barley, I would have to submit that it would be, well, not the onus. It would be, with respect, it isn't the onus, it's the...
maybe an evidentiary burden. Yeah.
I was about to say, the duty to adduce evidence in order to put the respondent's case before the court, but the overall onus to establish liability and negligence continues to rest on the plaintiff in the case, the present applicant. But there was certainly a duty to adduce evidence, which we say was adduced. This court does not have the benefit of that evidence before it. And obviously of relevance to that evidence is what was placed in issue in cross-examination. So we clearly accept the evidentiary burden, yes.
And has that evidentiary burden been discharged? Do we know what Ms. Barley did when she visited the school? In particular, do we know whether she inspected the outside equipment and whether she found that the equipment was in good working order?
She did not. I don't want to go, as I say, off the record in this matter, because with respect, I consider that would be inappropriate. But to the extent that you asked me a direct question, Justice Tron, I can submit to you that she certainly did not conduct the sort of inspection that the applicant relies upon, which is a physical inspection, tugging at the equipment, inspecting it to see whether it's sound. She would at best, and this has always been the respondent's case, she would, as with any other lay observer, and that was the case, and that was the basis of the cross-examination that I conducted in the court. So I feel comfortable telling you that. Our position has always been that if the inspection, or not the inspection, sorry, the quality assurance review, and can I just say, that we have no issue with our learned friend's submission, that what Regulation 30 sub 4 envisages is physical attendance, is actual attendance at the facility. It's not a desktop exercise conducted from an office at head office. And he himself says that, in fact, Ms. Barley did more than the requisite biennial, every 2-year inspections. So there's no issue there between us. But our position has always been that those inspections, if something clearly untoward was observed, such as broken glass or a hole or an unenclosed pool or exposed wires or indeed a broken swing, that would obviously be brought to the attention of the operator of the facility. But our case has always been that there was no obligation to go beyond that and inspect for safety every single piece of equipment at every single facility where these reviews are carried out. And that was the thrust of our case, and that was what the SCA found. And we submit that is a correct conclusion on the facts and on the law. I don't know whether that answers your question, Justice.
But is that sufficient, Mr. Jamie? Is that sufficient? Why would the person need to be appropriately qualified if all they have to do is look at everything and not examine?
Justice Strong, that is the heart of the case. And perhaps I should get to that. I've been dealing now with factual issues, which I didn't want to dally on for too long. So to get to the heart of the case, this case concerns a legal question. And the legal question is whether or not there was a legal duty, and I emphasize the word legal, a legal duty on the respondent to take reasonable steps to ensure the safety of Janneke whilst in the school's premises. And in particular, whether its officials should have inspected the playground equipment at the school as part of the biennial review of the facility. That is also how the SCA saw the matter, and I can give you the reference. It's para 9 of the SCA judgment at page 194. Now, to answer that question, you obviously have to begin resubmit with the wording, because if there is not, so to just remind you of the argument and the case of the applicant's case is that it was necessary to, and can I just perhaps say this at the outset, this entire edifice that they have erected in this case rests ultimately on a rather flimsy and narrow plank, and that is Regulation 34. The rest of it is put up as surrounding context and so forth, but the operative provision is Regulation 34. Now, to begin with that, can I just make the following points? The SCA found, as a matter of law, not fact, law, that nothing in the extensive regulatory regime that regulates early childhood development centres, formerly places of care, as Bubble and Crubble, now ECDs, contains an express provision, or any provision, which requires the respondent or its officials to conduct inspections for safety of facilities. That's the finding that the SCA made in this matter. So that's the first legal point we rely on. The second is this. Flowing from that, the basis for the liability which the applicant seeks to impose on the respondent is sourced not in a section of an act of Parliament, but in a regulation. And that has immediate consequences, both of interpretation and of context and of constitutionality, because as a matter of law, we submit a regulation cannot impose a substantive obligation, a substantive legal obligation on the respondent, which is not sourced in its governing legislation. If it sought to do so, it would be ultra vires and unconstitutional and unlawful. So the tail cannot wag the dog. A regulation can't do what an act of Parliament is required to do, and our learned friends do not rely, that much is clear, on any act of Parliament. They rely on regulation. If there's any doubt, if there were to be any doubt about that, I can do no better than to ask you to just make a note of paragraphs 54 and 55 of the applicant's heads of argument in this matter, where they say, given the plain wording of Regulation 34, it simply cannot be the position that the minister's functionaries are merely enjoined during the 2 yearly quality assurance reviews to ascertain whether the organization operating the school and its personnel are suitable to manage and conduct the place of care. And then in 55, given the overarching importance of ensuring the safety of children at places of care, the wording of the Act, and specifically Regulation 34, should be interpreted as contended for on the applicant's behalf, namely that it imposes a duty on the minister to appoint suitably qualified persons to inspect the outside play equipment for safety. Now, my learned friend, in reply, if I'm wrong on this score, will identify the statutory provision he relies on, but we submit there is none. He relies squarely on Regulation 34, and our submission is Regulation 34 can't be used to do the work that an Act of Parliament should have done. But then let's go to Regulation 34 to the extent that that's the fons et origo of the argument. If you go to Regulation 34, it simply doesn't say what the applicant wants it to say. Now, Regulation 34, it's referred to in various parts of the record, says, and in our heads of argument, we deal with it in its context, that it's part of, obviously, the wider part of Regulation 30, which deals with, and perhaps I should just try to take the court to where that is dealt with. Yeah, it's dealt with on page 18 of our heads of argument at para 54. And the first point I'd want to make is the Regulation 30 sub 1 says that an application for registration of a children's home, place of care or shelter, we know this was a place of care, in terms of section 30, brackets 3 of the Act, shall be made on the form determined by the Director General. Then sub-regulation 2 provides for what must accompany that application, and we know it includes the constitution of the association, that is to run the facility, a certificate from the local authority that the facility complies with all the structural and health requirements of the local authority. I might interpose that is the only provision in the regulation that speaks to questions of possible safety and structural integrity and health requirements. And then C is a certificate issued by the Director General, confirming that a needs assessment indicates that the facility is still required by the community. And then D is irrelevant because it deals with residential care minimum standards. So that is clearly what the regulation is envisaging. The registration process encompasses that they must be satisfied as to those matters which are clearly referenced in 32. And then 4 says, the operative provision, registration of children's home, place of care or shelter shall be reviewed every 24 months on the basis of a quality assurance assessment undertaken by appropriately trained officials appointed by the Director General. We say a number of things flow from that provision. The first is it speaks to registration. It says registration of a home shall be reviewed every 24 months. So that's the first point. What is being addressed? Registration. In fact, we know re-registration because registration is only for 2 years. So what we're now dealing with is re-registration after every 24 months. The second thing is the term used, which is a quality assurance review. It does not say an inspection. It does not say shall physically be inspected, the equipment. It doesn't say that. So the job that the applicant wants regulation 34 to do must be read into it. It certainly isn't what it says. And this brings us to the other aspect which we've dealt with, and that's in the context of whether this case raises a constitutional issue so as to engage the court's jurisdiction. Because we say this is not a case where the applicant for leave says, well, there is a statutory provision, and we say it must be interpreted in a particular way in light of a particular constitutional norm or rule or principle in order to be properly understood, and thus it raises a constitutional issue. If I understood the applicant's argument correctly, and if the applicant is correct, then every interpretation question, every time any statute or statutory provision must be interpreted, which happens in every case, that would raise a constitutional issue. And that is because they peg it on 39.2, which says when interpreting any legislation, every court must promote the spirit, purport, and objects of the Bill of Rights. That is not a free pass to giving every applicant, every litigant, in every matter where any statutory provision is at issue and must be interpreted, doesn't give them leave to say this is a constitutional matter that warrants the attention of this court, because then there would be no filter, there'd be no bar. So that's a wrong, incorrect submission of law, and that's. So
Jamie, sorry, may I interrupt you? The question that I had originally also ties up to this, and this is the question of jurisdiction because it concerns the facts. But my question relates to the agreement that my sister Theron raised with Mr. Sholto Douglas.
Yes.
It is so that the evidence is not before us, but perhaps it's not necessary to refer to it. Can I just check with you? Does the minister dispute that the minister had accepted by agreement with the municipality the duty to inspect the playground equipment for safety?
Absolutely, Justice. That was never accepted by the minister, by the MEC. The MEC was placed in total dispute, was placed in heavy dispute, and was a matter upon which there was no agreement. The minister never accepted that, either in the pleadings, either in the pleadings or in the course of the trial.
Now, you pointed out that what was pleaded as the legal duty that was breached was the duty of the minister to inspect. You referred to the pleadings in that regard, in the particulars of it.
That's correct.
Now, the best I can do is, in the absence of that evidence on the record, is to refer to the High Court judgment, and I would like you to go to volume 4, if you don't mind. just acting Justice Seaver's
Could you
judgment.
just give me a page reference?
Yes, page 232. I'll start at page 232 of that volume 4.
232, yes.
Now, this is a summary of the evidence, and the judge says that he refers to the evidence of Mr. Blankenberg. That is a witness that the minister called. Mr. Blankenberg was the supervisor for the department in the Overberg region, you'll recall. He says at paragraph 14.9, 14.8, Mr. Blankenberg agreed that in terms of regulation 30 sub 4, the minister had a duty to ensure that safety of children at the school. This task had to be undertaken by the DG on behalf of the minister. And then at 14.9, he refers to the document, which is a physical standards document. And 14.11 is the one that really interests me. It says that the document recorded an agreement as to which functions had to be formed by the minister and which function had to be formed by the municipality. And Mr. Blankenberg accepted, he's testifying for the minister, that the minister's tasks, according to the document, included having to take responsibility for the safety and suitability of outdoor apparatus and toys. And he suggested that this related only to equipment used for educational purposes. So that bothers me. There's also the evidence of Mr. De Bont, which is at page 234 summarized, and Mr. Marais.
Justice Majid, can I address you immediately on that evidence?
Yes.
Or do you first want to take me to the other evidence, Mr. De Bont?
No, let's deal with this one.
Justice, sorry, I'd forgotten that this was before the court, so I can then address it because you've now referred me to it, page 232. So when I indicated that there wasn't, I wasn't going to address you on the memorial of the agreement, this is the document referred to in 14.9. That was the memorial. And as you can see there, it is a document headed application of the minimal physical standards. So what it was a purported minute of a stakeholders meeting on 6 November. As the best of my knowledge, the persons at that meeting, I don't believe it didn't include Mr. Blankenberg, did it? Mr. Blankenberg, to the best of our knowledge, was not party to that meeting. He's not one of the persons. I can't recall whether Mr. De Bont and the other gentlemen were. De Bont possibly was there. But what it isn't, Justices, was a signed, considered agreement to transfer powers or responsibilities as one would expect, and as I believe the Constitution provides for, where you have the assignment of powers between different tiers of government. It never reached that level of formality. It was a poorly, if I may say so, a poorly worded and clearly not intended to be a formal memorial of a solemn assignment of functions between different levels of government. So that's the first point. It wasn't a signed document, and it was a memorial, and it was a minute, and it was by no means clear as to that it was complete. The second aspect, which is vital, is what you've adverted to, is contained in 1411. Although the document did purport to assign, or I'm using the wrong word, assign is too formal and elevated a word. Although the document purported to identify, it was unclear, and that's why Mr. Blankenberg had that reservation. He said, well, if you look at it, it appears to only refer, and I can't recall, and I don't want to mislead you, and I really don't want to go off the record, I can't recall what the wording was. What I do, however, I can submit to you that there was something in the wording relating to the equipment that made Mr. Blankenberg and us indeed believe that it referred to the sort of equipment referred to by the SCA in its judgment, which is equipment for the purpose of developing children's motor skills, etc. In other words, not ordinary play equipment, but what is the word? Assistive equipment and developmental type equipment. So
yes, no, I understand that he calls it educational purposes. All I want to add to conclude is that at page 234, Mr. De Bont and Mr. Marais, who testified then for the municipality, also adverted to the memorandum of agreement, as they call it, to November 2000 agreement, in terms of which the minister was tasked with the function to ensure the safety of outdoor apparatus and toys. But I mean, the answer would be the same. I just wanted to raise it with you because it's not in the record, it's in the judgment.
I must apologize. In hindsight, one can always see perhaps other things should have been included, but one tries to follow the rules of report. But can I just add this, Justice Majid? In considering that, and as unsatisfactory as the evidence is before you as to the agreement, etc., one must bear in mind two things. The one I've already alluded to, which is government is not able willy-nilly to, and I don't have the particular provision of the Constitution at hand, but I'm sure the members are aware of it. Government can only act, and any memorial of governments, of the conduct of government in whatever sphere must be in writing. Government doesn't act orally, and for government's conduct to have the force of law, which is obviously a requirement of the principle of legality, it must be in writing. So that's the first point. And here there is, as I say, all we have is a purported minute. The second point, and we allude to this in some detail in our heads, and I'll just give you the reference, is you will bear in mind in considering firstly, the existence of such an agreement, and secondly, its relevance to this case, you will have to bear in mind, we submit our submissions and our references to the obligations on a municipality. We refer to the fact that the obligation to undertake the obligation to establish childcare facilities is one that is a functional area of concurrent national and provincial legislative competence. But in Part B, childcare facilities is a local government matter to the extent set out in sections 1556A and 7. And those are matters which a local authority has the right and obligation both to administer and to, in fact, pass legislation for. Bylaws for.
Excuse me, know here. I was still looking at the record. I missed you there. What are you referring to?
Sorry,
I'm sorry about that. I'm sorry to take you back.
No. I'm referring to as just a legal what flows legally from our submission with regard to the purported agreement. The submission is that regardless of what first you've got to decide whether there was an agreement, but secondly, its relevance to this matter must be considered in the context of what the constitutional and legal obligations of the parties are. We're not dealing here with private parties who can simply contract, who have freedom of contract between each other. We're dealing with organs of state, which if they have agreements, and this was the submission I made earlier in response to Justice Majid, certainly the law and the Constitution provides for assignments and delegation of powers and assignments. But that must happen in a formal manner, and there must be a written memorial and a written agreement. That's how government works. Government doesn't work informally. It doesn't work in terms of verbal agreements. And there's no evidence of such an agreement before you that was ever signed that raises this supposed understanding or agreement to a formal one, which would have the effect lawfully, constitutionally, of transferring powers from one tier to another. So that's our principal submission. But the secondary submission is here, they were very definite. The constitutional obligation and right to administer childcare facilities is found in Part B of Part B of Schedule 4 of the Constitution. Childcare facilities, Part B of Schedule 4. That's a local government matter for local government to administer and for it, if it so chooses, to enact legislation for. And we know that the relevant local municipality here, Overberg, did enact such legislation. It was before the court. It's attached to our heads of arguments and to the appendices. It's attached to the record in part and to the appendices. We deal with that from page 21, para 61 onward. And the important provisions is, unlike the tortuous reasoning and the tortuous arguments you hear in order to make a square hole fit a round peg, which you find from the applicant in relation to Regulation 34, you have no such difficulty with recognizing a clear legal obligation on the case of municipalities to inspect for safety. Because the relevant provision in the case of municipality, this municipality, was the following. It's section 34 of the bylaw, which is referred to in para 63 of our heads of argument. It says, so this is what the bylaw says in respect of this very facility. Every childcare facility shall comply with the following requirements. The premises intended to be used or already in use as a childcare facility shall be in good structural order and repair both internally and externally. That is the obligation that the municipality imposes on childcare facilities in its area. And then all furniture, fittings, and equipment provided by the proprietor shall be clean and in good order and sufficient for the purpose. So all equipment provided by a proprietor must be inter alia in good order. Now the language couldn't be clearer, Justices. And then section 35 backs that up by saying any person contravening any provision of this part shall be guilty of an offense. And then section 44 says that any duly authorized employee of the municipality is authorized to inspect any premises within the municipal area in order to determine whether there's compliance with the provisions of this bylaw. And then, mirroring, as it were, 34, but more directly, we say, section 44.3 says the authorized employee may be accompanied by a person reasonably required to assist in conducting the inspection. So clearly the bylaw recognizes or envisages a physical inspection, and that the person who goes along with the inspector or the authorized employee will be a person reasonably required to assist not in the quality assurance review, but specifically in the inspection. And we submit those provisions lay to rest the notion that there was a corresponding obligation on the respondent and that there wouldn't be, that the applicant has no recourse unless it lays responsibility, unless this court finds responsibility, intellectual responsibility must be imposed on the respondent, the applicant would be without recourse. That's not true. So we say on a proper understanding of the, and to get back to your initial question, Justice Strawn, I've taken a long way around to answer it, but I felt it necessary to put all of this in context. And the submissions I've just made to you go to the heart of our case. We submit that we accept that Regulation 34 must be construed within constitutional parameters, but no amount of constitutional tweaking and constitutional analysis can turn a fairly mundane, run-of-the-mill provision like Regulation 34, which clearly deals, we submit, with the question of registration and re-registration, can turn it into something that must carry the obligation to ensure the physical safety of children. Obviously, the physical safety of children, and indeed the emotional and mental safety, is at the heart of the entire enterprise which the departments of social development throughout this country have to bear in mind when they carry out their statutory and constitutional obligations. That goes without saying. But that is not non-constant. That does not translate into an obligation that with each and everything they do, that is the purpose. That is to conflate broad, objective and statutory interpretation. Regulation 34 simply doesn't require physical inspections for safety. Why doesn't it do so? It doesn't do so because it's dealing with registration. The second reason it doesn't do so is because the Act doesn't require such inspections for physical safety. Where the Act does, and the relevant part of the Act, or the relevant section of the Act is Section 30. Section 30, sub 3, and you will recall Regulation 30 references in 30, sub 1, Regulation 31 references this section, 33. 33, the section refers to an application for registration of inter alia place of care. And then A says, before considering such application, the Director General may require that he or she be furnished with any information in connection with the application concerned or the proposed place of care, which he or she may desire to obtain. And then B, reject any such application, or if he or she is satisfied that the children's home, place of care, or shelter complies with the prescribed requirements, and that it will be so managed and conducted that it will be suitable for reception, care, and bringing up of the reception, care, and custody of children, grant application, either unconditionally or on such prescribed and other conditions as he or she may deem fit. So that's the statutory matrix and underlying provision, which the regulation then gives effect to. But that provision, B, that I've just read to you, does not require, in its terms, it doesn't require physical inspection. It says that what the Director General must be satisfied as to is that the children's home, place of care, etc., complies with the prescribed requirements, and that it will be so managed and conducted, and those words are important, managed and conducted, that it will be suitable. And that's why the emphasis is on the personnel and the constitution and the structure of the facility, and whether there's a building certificate and whether there's a need for it. The Director General's concern is not the physical safety and the physical appropriateness of each and every piece of equipment. If its officials go to a proposed place of safety and they see, for instance, that it has an unfenced pool, that's an obvious red flag. And then they're going to say to the proprietor, sorry, we can't authorize, we can't give you a certificate till you enclose this pool. That's fair enough. If they see broken windows, doors, dangerous things lying around, they are going to say, sorry, till this is cleaned up, we can't give you. All of that is common sense, but it doesn't follow that they are going to physically go and tug on play equipment, inspect all the gas lines, inspect the furniture, inspect the ovens and the gas hobs, inspect the wiring. That with respect is unreasonable and it's unnecessary. But whether you think it's reasonable or not, it certainly is not what these provisions require. It's not what Section 30, sub 3B of the Act requires. And if you are in agreement with me on that, and I didn't understand the applicant's case to be that that is what 30, sub 3, sub B requires. If I'm wrong, my learned friend will put me right. But we say it's clearly not what 33B requires. You've heard no argument that in terms of 39.2, the statute must be interpreted in a particular way, which is why we say it doesn't raise a constitutional issue. But if you are correct with me if you're with me that I'm correct, that is not what it says, it follows inevitably that the regulation, which is its progeny, can't say that, can't impose such a requirement, because then it would be ultra vires. It's governing legislation. So that is our principal submission, that on its ordinary wording doesn't say that. But we then go further and say, well, if you were to find that it does require physical inspection, we submit for all the reasons set out in the SCA judgment and in our heads of argument, it doesn't say that. You then still have to consider whether the breach of such a statutory obligation is itself sufficient to translate into what the justices referred to in the debate with Mr. Sholto Douglas as being a private law duty. And the answer to that question is to be found in Litsky with respect and in Mashongwa. And we do refer to Mashongwa, and we are in agreement with our learned friends that Mashongwa is an important case. Of course, we disagree with the implications and the consequences and the effect of Mashongwa, because we say Mashongwa clearly deals with a different scenario and a totally different situation. And thus it doesn't assist. In fact, it demonstrates why our learned friends are wrong. I just want to go to where Mashongwa, where we deal with Mashongwa in our heads of argument, justices. We deal with it in para 47 of our written argument. And the court says, and we submit this summarizes as well as anything, the proper legal test and proper legal approach to this question of wrongfulness. This court said, to conclude that an incident of omission, particularly in relation to public law duties, is wrongful and impute delictual liability is an exacting exercise that requires a reflection on a number of important factors. Some of them are whether the operating statute provides for delictual claim for damages, whether the legislation scheme is primarily about protecting individuals or advancing public good, whether the public power conferred is discretionary, whether the imposition of liability for damages is likely to have a chilling effect on the performance of government functions, whether the loss was foreseeable, and whether alternative remedies such as an interdict review or appeal are available to the claimants. An omission will be regarded as wrongful when it also evokes moral indignation and the legal convictions of the community require that the omission be regarded as wrongful. This leads to a legal policy question that must of necessity be answered with reference to the norms and values embedded in our constitution, which apply to the South African society. And every other normal value thought to be relevant to the determination of this issue would find application only if it is consistent with the constitution. As Moseneke DCJ put it, the ultimate question is whether, on a conspectus of all reasonable facts and considerations, public policy and public interest favor holding the conduct unlawful and susceptible to a remedy in damages. We submit, justices, that when regard is had to that dictum, the indications all are, they point away from any breach of a public law duty, if you were to find such in this case, to translate into a private law obligation to pay damages. The first and most obvious reason is the reason that was enunciated upon and referred to by the Supreme Court of Appeal, namely that, and I think it was in Bali, not in this case, that the purpose of the suite of legislation here at issue, that includes the Children's Act, even though that was not relevant in this case, it was relevant in Bali. The purpose of this legislation is not, and on its clear face, it's not, to impose delictual liability for individuals who feel wronged by a breach of a regulatory duty. It is to serve a greater good, which is to make sure, in pursuance of Section 28 of the Constitution, that there is a scheme throughout the country which is not run by or offered by the state, but which is overseen by the state, which is largely, if not almost exclusively, operated by private individuals and NGOs, which provides for the temporary partial care of children while their parents are unable to care for them. In other words, daycare centers and partial care facilities, which many people, including working people, require in order for them to go and do their work. They need somewhere to leave their children, which is safe, and where they can be assured that children are well looked after. And government's obligation is not to run those, it's not to send DIY people around to check those facilities on a day-to-day or regular basis, but to put in place an administrative regime which they oversee on a regular basis and which makes sure that the people who run those facilities are fit and proper, basically, to run them in a safe and suitable and appropriate manner. That is government's task. And then the second important part of government's task is to facilitate financial support if required. And that we know also happened here. Those are government's obligations. If this court were to agree with our learned friends' contentions, it would turn, as the SCA said, departments of social development throughout the country, not only the Western Cape, throughout the country. And in this regard, it doesn't matter. My learned friends sought to make something of improper evidence, etc. It doesn't matter because we know the court can take judicial cognizance thereof, that there are literally tens of thousands of these facilities throughout the country. They serve a vital function. Government, through the provinces, regulate all of them and oversee all of them, but they can't do so on a daily or weekly basis. That is why there's a registration requirement and then a biennial, every 2 years requirement. And we've made the point, if the purpose of this quality assurance review, which is not defined in the Act or the regulations, was to inspect for safety, then it's bizarre with respect, because every 2 years would be woefully inadequate. And it's not an answer to that to say, well, in this case, it happened more often. That's happenstance. That's not a legal obligation. If the legal obligation is every 2 years, that's not a safety, that's not sufficient. Can I just contrast the Section 30 registration requirement with Section 31, which is a different requirement? Section 31 of the Act says that a social worker, nurse, or any other person authorized by the Director General may enter any children's home, place of care, shelter, or place of safety in order to inspect the place or observe and interview any child there. And then section 31.4 says the social worker, nurse, etc., shall submit a report to the Director General after the performance of the function referred to in subsection 1. And then the powers of the Director General on receipt of report shall be as prescribed. Now, the relevant regulation, Justices, which deal with that, and which we put up in an appendix to our heads of argument because it wasn't contained in the it was confirmed, so I can just try to find this. Regulation 34A. So I can't find it at the moment. I may be wrong that we put it up, but it's Regulation 34 capital A. We seem to have omitted to do that. I apologize. Sorry, Justices. I apologize for that. I appear to have omitted to include that. But Regulation 34A deals with the inspection envisaged in section 31, and it's clear from that regulation, 34A, that its introduction references...
as you passed it.
I'm sorry?
Please proceed, Mr. James.
I'm sorry. Regulation 34 capital A references section 31.4, and it says on receipt of a report referred to in section 31.4 of the Act, indicating that requirement for registration of a children's home, etc., has not been met, the Director General shall, and then A to F list a series of things the Director General must do, and it's quite clear from that they are things directed at the better development and improvement of management's position vis-a-vis its operation of the centre. So, for instance, A says it must inform management and the head of the children's home of the contents of the report. B, where necessary, require the head and management to respond to the report. Then C is important, provide a developmental program, guidance and support to enable management and the head to meet the requirements within a specified period, being not less than 2 months and not more than 6 months of receipt of such report. This is referred to in the SCA judgment. So they are given an opportunity to respond and so forth. And then it's only if the report indicates that there has not been a satisfactory response, the Director General then may withdraw the registration certificate, instruct the place of care to arrange for the transfer of children to another registered facility, and then close it down. So that follows a process. It doesn't happen automatically. And then, by contrast, Regulation 34A sub 2, also referencing 31.4, says that if there's a concern about any matter relating to the care, protection, or development of children in terms of Regulation 31A, then the Director General shall inform the head of department responsible for such place of care of the contents of the report, require the head of the department to respond in writing. C, instruct the head of department to provide a development plan, guidance, and support for the facility. After the period referred to in sub C, regulation sub C, give instructions for re-inspection of the children's home, place of care, and for a report thereon to be furnished. And then, if the report indicates that the concerns have not been satisfactorily addressed or remedied, request the head of department to take whatever steps he or she deems necessary and report back. Yes,
Mr.
Justice.
Jamie, sorry to interrupt you. The report that's envisaged in Regulation 34A will only arise as a result of an inspection in terms of Regulation 30 relating to registration. Is that right?
No, that's not correct. That's why I've taken some time to go through it. The Regulation 34A report has nothing to do with Section 30 or Regulation 34. it happens pursuant to section 31. So section 31
Wait,
is
before you
where
take us to section 31, 34A1 says on receipt of a report referred to in section 31(4).
That's correct. So that's why I'm saying
Indicating that a requirement for registration, because this is also dealing with registration. A requirement for registration of a children's home has not been met.
I'm sorry, Mr. Strong, with great respect, that's not correct. Section 31 does not deal with registration. Could I ask you if you have the legislation before you? Section 30 of the Child Care Act is headed Registration and Classification of Children's Homes. And the operative provision is section 30 sub 1, which says no child may be received in any children's home unless that children's home is managed by an association that has been registered under the section, or otherwise in accordance with the conditions on which the children. So that's the operative provision. You may not operate the children's home, which has not been registered.
It might be in different sections, Mr. Jamie, but it relates to registration.
No, it doesn't, with respect, Justice. It relates to a complaint or a concern arising. It happens quite independently of the biennial registration. It's got nothing to do with the biennial registration. The trigger for section 31 inquiry, and that's why these specific remedial provisions referred to, is a concern that arises. Although the section doesn't make that clear, the regulation makes it clear, which is why I took you to the regulation, because the introductory words to Regulation 34A are crucial to understanding the distinction. Regulation 34A sub 1 says on receipt of a report referred to in section 31(4), which we know is pursuant to section 131 procedure, indicating that a requirement for registration of a children's home has not been met. Okay? The requirement for registration of a children's home has not been met. And to the extent it refers to registration, we submit that's a reference to the ongoing registration. It's got nothing to do with a quite separate statutory requirement of a biennial quality assurance review for purpose of extending or renewing the registration. That's not what the reference to registration in the introduction to this regulation refers to. This regulation, when it refers to registration, means a requirement for the ongoing. It should have words read into it to mean for the ongoing. In other words, that it still is complying with its registration requirements, because that's the overall issue. So if there is a concern raised, not only about the facility, but about the children, then that gives rise to your section 31(4) report. And the consequences of that report, as section 31(5) says, are as prescribed. And this regulation deals with the sequelae of getting a section 31(4) report and how that report is dealt with. It isn't dealt with by, and it's notable that even if they were to pick up, let's say, a problem with the play equipment, it's not that the respondents' officials are required to inspect that or to remedy that. They have no direct powers in respect of safety. All they can do is tell the official, tell the operator, there's a problem with your equipment. And that is, sorry.
These regulations and the section relating to registration, it can be the initial registration, or it can be ongoing registration, but it all relates to the registration of the child care facility.
Can I respond to that, Justice?
Yes, please.
We say the distinction is between the clear wording of section 30 and regulation 30, both of which deal with requirements for registration, whereas 31 and regulation 34A are dealing with something different. They may intersect in the sense that when you do your regulation 30 sub 4 inspection, you pick up something which then becomes a section 31 issue and which then results in a 34A 34A report, but non-constant that it must. Regulation 34A deals with a wider obligation and entitlement. And that's why a nurse can go in and do an inspection. If they have received word or some information that there's a problem or potential problem, they can go in and do a 31 inspection. They can't just arrive and do a 34 quality assurance review at any time they like. They must do it upon re-registration. So that's the distinction between the two.
What is the respondent's submissions in respect of who or which functionary has the responsibility to ensure the safety of the outdoor equipment?
The first level of functionary is the operators of the facility. That much is clear. They must do so. They're responsible for the equipment. But the second level of intervention and supervision is clearly that of the municipal health authorities. And that is why they've got the express. And remember, there's provision we've referred to in our heads. The bylaw here, the overbid bylaw, prohibits the operation of such a facility without an application to it. It charges a fee for such an application. There's no fee charged for the respondent to conduct the quality assurance review. It charges.
Let me narrow my question, Mr. Jamie.
Yes.
If I understand the position of the respondent says that in the 2-yearly inspection,
yes,
the appropriately qualified social workers do not need to inspect the outside equipment. They notice something that is wrong. You've pointed on a number of occasions to perhaps a swimming pool that doesn't have a cover. Yes. Who or which functionary has the responsibility to inspect the outside equipment to make sure, like, for example, in this case, that the swings were operating properly, that there was no defects? What is the respondent's submission on that?
It's always been that it was the municipality's responsibility, because that's what the Constitution imposes on them, and that's what they've understood and taken responsibility for. That's why they have the bylaw that they have, justices.
So it was the respondent. So the minister says that it was the municipality's responsibility to physically check the outdoor equipment.
Well, the first responsibility was the operator, but the enforcement of the operator's responsibilities was, we submit unequivocally to the municipality.
Did the minister, in terms of that loose agreement or memorandum of understanding, not then accept that responsibility in the stead of the municipality?
No, Justice. For the reasons I've already given you, that cannot be a finding that this court makes. The first reason is that the evidence isn't before you, and it was never, and I must emphasize this, it was never accepted by the respondent that was its responsibility. Never. Mr. Blankenberg's evidence goes no further than saying, and he wasn't, to the best of our recollection, party to that meeting. He does not say that that is what it means, because he says he thinks, and it's just his opinion. And that's the point. Everyone else, and you know the law regarding interpretation of agreements. This is, and I emphasize again, this isn't even an agreement. The memorial here appears, not appears, it is a minute. So you don't have a document that is intended to be a written memorial of an agreement. That's the first problem. The second problem is it's not before you, so you can't undertake the constitutionally compliant interpretive exercise, which the recent law, which you are as well aware of as I am, enjoins upon you in construing a written instrument. You can't undertake that exercise. So our submission is the whole agreement is, although an interesting oddity, it's a red herring because it simply isn't before you. You do not have the means or the resources to interpret the document in order to make any finding on it, let alone a finding of liability against my client, the respondent. You simply don't have the document before you, can't undertake that exercise. But even if you were to be attracted to the idea that you should undertake that exercise, the difficulty with respect is that we run into then other constitutional legal issues. And as I've said before, I don't have the provision. Well, it would be dealt with in the Constitution, but the executive authority of government has to resubmit in fact, could I ask, or could the court have regard to well, sorry, that goes the other way. But Section 126, for instance, of the Constitution makes provision that a member of the Executive Council of a province may assign any power or function that is to be exercised or performed in terms of an act of Parliament or a provincial act to a municipal council. An assignment must be in terms of an agreement between the relevant Executive Council member and the municipal council, must be consistent with the act in terms of which the relevant power or function is exercised or performed, and takes effect upon proclamation by the Premier. Now, I haven't prepared on this because it wasn't part of the case that was advanced.
Mr. Jamie, perhaps I can assist. It's Section 101 of the Constitution in respect of powers exercised by the President, and for the local government, it is executive decisions. Decision by the Premier must be in writing in Section 140.
Sorry, I'm looking at Section 101, Justice Majid. 101 deals with the decision by the President.
140 is for the Premier.
140 is for the Premier, and I was just looking to see whether there was a corresponding. 140 is a decision must be in writing. That's correct. Now, I just want to see whether there's a corresponding provision for local authorities. But those are the two provisions. I'll thank you for that. Those are the two provisions that I had in mind. The nearest that it appears to approach is Section 160 of the Constitution, which deals with internal procedures of the municipal council. So the first point I'd like to point out, the first aspect I'd like to deal with is Section 161 says a municipal council makes decisions concerning the exercise of all the powers and the performance of all the functions of the municipality. Now, if we can just stop there, and that has resonance in the corresponding provisions, and in fact, the one that I read to you regarding the assignment of powers by a province to a municipality, because it did say that the agreement must be with the municipal council, if you'll recall. So the municipal council is the body, the elected body, which makes decisions on behalf of the council. And we submit that, and it was never the case, and that's not the argument, that it was a municipal council. This supposed agreement, call it what you will, was a loose agreement reached at a meeting between various officials. There's no indication that this occurred with the knowledge and or approval of the municipal council, which is why it's a dead end. It's a red herring because it never had the basis of law. Officials can't decide with other officials to delegate the constitutional statutory power from one tier of government to another, and then not even reduce it to writing.
The section in the Constitution that you first referred us to, Mr. Jamie, speaks about the assignment of powers.
Sorry, can you just remind me of that section, please? It was section.
The section that speaks about the assignment of powers from the MEC or to the provincial council. In this instance, we're dealing with a situation that's in reverse, where allegedly the MEC took on the obligation that was on the municipality.
Yes, I know, but I've just pointed out to you, Justice Strong, that 161A of the Constitution says that a municipal council makes decisions concerning the exercise of all the powers and the performance of all the functions of the municipality. Now, our submission would be that even if there were such an agreement, absent an allegation or proof that the municipal council authorized it and the municipal council decided either by way of a subdelegation to these officials, or it decided it by itself that it was going to agree with the provincial authorities to transfer this power, an obligation to them, then this doesn't get out of the starting blocks. So it's not good enough to say our officials sitting in a meeting reached an agreement which isn't even memorialized in a written agreement that is signed by the parties. It doesn't assist. It's a red herring, because unless it was approved by the municipal council, it is of no weight and lawful force. That's our submission. And that was never the case. No one ever suggested it was an agreement that had the imprimatur of the council of the Overberg Regional Services Council. I think I have run out of time, unless I don't know whether there are other issues, but I've made the submissions that I wish to make. Justices, our submission is that the application for leave to appeal founders on the triple requirements for applications for leave to appeal. They've not established that there is a constitutional issue here, notwithstanding my learned friend's submissions about sections 28.2 and 28.1c, for the reasons I've already advanced. There is no arguable point of law, given the findings in Bali and in the Supreme Court of Appeal judgment in this case. And we emphasize the fact that Bali was implicitly approved of by this case, this court, when it refused leave to appeal in the appendix which we've attached. And our learned friend made no submissions in that regard. And lastly, it's not in the interest of justice to grant leave to appeal for the reasons set on our heads. Then with regard to the central question of, and it's a bifurcated question, the first part of the question is the proper interpretation, taking into account constitutional norms and so forth, of Regulation 34 and of the rest of the legislative landscape. And we submit that our submissions there deal with the matter. It is not the regulation plainly and clearly doesn't have the meaning it sought to be attributed there to by our learned friends. The second part of the inquiry is then the wrongfulness aspect. And if it does amount to what the applicants say, and this court were to be of the view that there's been a breach thereof, would that translate into a private law duty? We submit for the reasons we've set out in our heads of argument and adverted to in these submissions, it doesn't. This case differs fundamentally from Mashongwa. Mashongwa dealt with a public carrier, where this court in rail commuters, you will recall, had already found there to be a public duty on the part of PRASA to secure the safety of rail commuters. And as it says in Mashongwa, it goes one step further in Mashongwa and says that public law duty now translates into a private law duty to pay damages if you don't. And that's readily understandable. If your function, your central function is to transport passengers, you obviously must be responsible for their safety. Here, it differs toto kala. The primary responsibility of the respondent is not the physical safety of children. That is taken care of by the operators of the facilities and by the municipalities concerned. The central function of the respondent and likely placed or similarly placed departments in other provinces is to look at the registration and oversight of those facilities and to support them financially if required. And then the remaining aspects we've dealt with negligence and causation. We submit this case does not get home on any basis. If you're with us, we ask that leave to appeal be refused, and we do not seek costs if we are successful. Those are submissions, Justices.
Thank you, Mr. Jamie.
As the court pleases.
Mr. Schulte-Douglas.
As the court pleases, I will deal with certain of the arguments raised by a learned friend in his answer. The first point he made was to suggest that this was an appeal that dealt with facts and therefore didn't engage this court's jurisdiction. We made the submissions in advance. It's not. The mere fact that facts play a part in, sorry, somebody's asked me to start my video. Oh, I beg your pardon. The mere fact that facts play a part in any interpretational exercise doesn't mean that an interpretational exercise or a determination of whether a public law duty should translate to delictual liability are not questions of law. They manifestly are. Then you've been taken through somewhat of a journey into the dispute between the municipality and the minister and the status of agreements or minutes of meetings and whether or not those are enforceable as between the municipality and the minister in accordance with the Constitution. That, with great respect, is all utterly irrelevant to the issue before this court. The question of the dispute between the municipality and the minister was resolved by the High Court. It was taken on appeal. It was not engaged with by the appeal court, by the SCA, other than to make an order dismissing the appeal in that regard. The judgment of the High Court stands. The findings of the High Court are of assistance to this court in that regard. It is not an opportunity to revisit the dispute between the municipality and the minister in this forum. There is a finding in the High Court that there was an agreement that is supported by the judgment at the passages to which Justice Majid, I believe, referred. It is not a written formal agreement. It is a minute of a meeting on the face of it. It reflects an agreement. The evidence had been concluded. And for the purposes of this hearing, it is sufficient evidence to establish how the minister understood her duties and obligations under the regulation. Then the court was taken through a peregrination of a number of provisions of the Act, the regulations, the municipal bylaw, and so forth, against the background of a submission that the applicant's interpretation of Regulation 4 was a tortured one. We submit it's not a tortured one. We accept that you've got to read Regulation 30 in brackets 4 in the context of the regulations as a whole, in the Act as a whole, the context and the purpose, and so forth. We have no quibble with that. But when one reads the plain wording of Regulation 34, you see a portion of that regulation that stands as completely unnecessary if it does not bear the meaning we submit should be assigned to it. And it's not, with respect, a difficult meaning to arrive at, that a quality assurance assessment be undertaken by an appropriately trained official. And it goes to registration. It goes to the continued registration, which is renewable in terms of the Act, or is not capable of being granted in terms of the Act for periods longer than 24 months. So what perhaps has been overlooked in the, if I may call it, ultra vires argument that is raised for the first time before this court by the respondent. In other words, the primacy of the statute over the regulations is the definition in the Act of the Act, this Act. The definition in Section 1 of this Act is stated to include any regulation made under Section 60. Regulations, Section 60, like many of its counterparts, gives the minister wide powers to regulate the act. This idea that a regulation is incorporated in an act is not foreign. The Income Tax Act, for example, incorporates all the double taxation agreements that are concluded with foreign countries. So with respect, there's no hierarchy. The regulations and the act must be read together because the act includes the regulations, and it says so in terms. Then we are told that we haven't raised the argument that this process of interpretation or assessment should be read through Section 39(2) of the Act. Well, with respect, we manifestly have, and even if we hadn't, it would make no difference because the court would be enjoined to do so. On the factual issue of Ms. Barley, she did carry out an inspection. We know that. Our learned friends call in aid what has been called that most blunt of intellectual instruments, common sense. And common sense is an appropriate resort in the right circumstances. We know that Ms. Barley went into the playground to do an inspection 4 months before the event in question. She didn't see that the swing was broken. Contrast that against the expert evidence of Mr. Hillman, who gave evidence on the basis of facts, not supposition, hypothetical conjecture, or anything of that nature. The facts set out in his expert report, which included an examination of photographs of the swing, which burdened the record before the SCA, but are not before you. And he, having regard to those and the history, the facts set out in his expert report, he drew the conclusion that the design was deficient, and B, that this would have resulted in excessive movement of the cross member as the strips began to fail, and that would have been evident to anyone who took the care to look. Now, if one applies common sense to both what Ms. Veingard says and what Ms. Barley says, we know as a fact that the minister did not see fit to make social workers appropriately trained persons for the purposes of the regulation. We know that. So common sense dictates that people who are not alerted to what they are looking for walk into a playground, and this is not on the record, as our learned friend says, and have a look around, inspect, whatever it is. They don't see it. They didn't do a proper inspection. We know that because neither Ms. Veingard nor anybody else who went out into that playground to assess the safety of equipment could have missed the deficiencies in the swing on Mr. Hillman's evidence had they been looking for them. And we're not talking about a detailed inspection, somebody who took the trouble to look. You were taken to Ms. Veingard's evidence to the effect that she was in the playground when the children were playing in the playground. That is correct. She was watching the children. She didn't watch Janica on the swing. She was aware that Janica was on the swing. She turned around, a child pulled on her sleeve. She turned back and she saw the swing had collapsed. There's no suggestion that she was checking the swing to see if it was operating safely. That's clearly not the case. And to refer to Ms. Vanguard and her colleagues as diligent caretakers, as our learned friend did, overlooks that fact, overlooks the fact that everybody concedes they were negligent. Yes, the swing was made years earlier, and it did take time for the swing to deteriorate to the point that it collapsed. But that could have been picked up, and that's simply the basis. And with respect, Justice Theron's point about the evidentiary burden is quite right. In these circumstances, the evidentiary burden is cast on the respondent to show what steps were taken and what could have been done. If I can just go back very briefly to the fight about the municipality. The argument, or much of the argument before you today, was that the municipality had the obligation under its bylaw to look after playground equipment. With respect, the interpretation of the bylaw doesn't support that, but even if it did support it, it doesn't detract in the least from the obligation imposed on the minister under Regulation 34. The purpose of the Child Care Act and the purpose of the regulations promulgated under it are to protect children. It is to look after the safety of children. How difficult was it to have prevented Janica from suffering a severe brain injury? How difficult is it to prevent this happening to any other child? Is it so difficult that the constitutional norms prevent this court from imposing liability in dealing? We submit not. We submit this is an appropriate case for the imposition of delictual liability, and we persist in seeking the relief we do. Those are our submissions.
Thank you, Mr. Schulte-Douglas. Judgment is reserved and the court adjourns.
Today's proceedings have concluded. The host will now terminate the meeting.